Hello, good afternoon, everyone. It's great to see a good turnout for this webinar. Thank you very much for attending this presentation. We're just getting started. This is about CRPO's recently updated professional practice standards, which came into effect on January 1st, 2024. I want to acknowledge that while we are meeting virtually, the CRPO office is located on the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and which is now home to many diverse Indigenous peoples. As we begin, we'd ask that attendees keep their cameras off. This helps avoid being inadvertently included in our recording of this presentation. The recording will be for anyone who would like to review again or who couldn't attend today. I'm Mark Pioro, Deputy Registrar and General Counsel at CRPO. I'm joined by my colleague, Pamela Bialik, Policy Analyst. On the next slide, I want to share what we'll be talking about today. First, we will explain what standards are and where to find them. We'll describe how CRPO's original standards were reviewed and updated. Finally, we'll summarize some of the changes, including the overall or universal changes to the document, followed by a top 10 list of where changes have been made. We'll share some next steps CRPO will be taking about the standards, and we'll close by answering some questions. Attendees were given the chance to ask questions in advance when registering for this webinar. We've integrated answers throughout the presentation, and we'll cover some at the end. There is also a Q&A function in Zoom where you can send in questions while we are presenting. We will likely not be able to answer all questions on the spot today. We appreciate any outstanding questions or feedback submitted. We will publish written answers after the presentation and make these available, along with the slides and recording, within about a month. If a question is very specific and we couldn't get to it, it may be best to email info@crpo.ca for general questions and practice@crpo.ca for inquiries about professional practice.
Before we get started on the major changes, I'd like to briefly go over what standards are. Our professional practice standards form the base expectations and non-negotiables of the profession. All RPs, regardless of client population or practice area, are expected to meet them. Our written standards are intended to assist registrants in the safe, ethical, and effective practice of the profession. They're reviewed periodically based on various factors, and as you may know, just underwent a full review and refresh a few months ago.
The standards are available on our website, crpo.ca/standards in English and crpo.ca/normes in French. A note about versions and formats. We first posted an unedited, unformatted version of the 2024 standards on our website so that registrants didn't have to wait to become familiar with them. The edited standards will be available as a single document containing all the standards, as well as on separate web pages, one for each standard. CRPO is currently going through a website update. You have a preview right now on these slides, a little bit about our upcoming visual identity. We are going to update the individual web pages for the standards when we launch the new website, likely in the spring or summer. In other words, for the moment, only the single document containing all the standards is available. Regarding the 2014 version of the standards, we are leaving them on our website as an archive for reference purposes so readers can see what has changed. It can be accessed through the All Resources page of the website. Also on the All Resources page of the website, you can find an abridged version of the 2024 standards with the commentary removed. It can be a handy reference at less than 10 pages long. There is also a summary document there describing the changes to each standard from the 2014 version to the 2024 version.
In order to update the document, CRPO took an exhaustive approach to each standard that began with a legislative review, a literature scan, a jurisdictional scan, and an internal data review focusing on content and practice inquiry data to help us better understand where registrants had gaps in their knowledge. Each standard was reviewed by our Quality Assurance Committee as well as our council and underwent consultations with subject matter experts and professional associations. As you may know, the standards also went a public consultation before finally being approved by our council. In total, about 64 people contributed to the work of the standards, not including the 64 submissions to the public consultation.
At this point, we'll begin discussing the changes to the standards, starting with changes to the document as a whole. We've reordered each standard, putting the standard itself at the beginning so it's easier to find and see what is expected right away. We have numbered substandards for easier reference and to separate different ideas rather than having long paragraphs. There is a new section containing key definitions for several standards, and the background section has been renamed commentary. Overall wording changes include referring to registrants instead of members. This is the preferred term in keeping with the college's public protection mandate and contrasts with professional associations that serve their members. We have also switched to gender-neutral language.
Now we can set out 10 highlights where the 2024 standards have been changed from previous versions. First, we've made some changes to Standard 1.6, Conflict of Interest, and Standard 1.7, Dual Relationships. Both were expanded to include an increased emphasis on clinical and ethical judgment when dealing with conflicts in dual relationships. More specifically, conflicts and dual relationships that arise when working in small communities where such conflicts and relationships are unavoidable or impractical to avoid. When we say small communities, we recognize that communities may be geographic, racialized, equity deserving, academic, professional, social, spiritual, cultural, or bound by any other unifying experience or characteristic, including disability, sexuality, or identity. And living and working within these communities means that there will be a certain level of overlap between the personal and professional realms. We've provided some additional guidance in both these standards to that effect. A related topic is separately treating individuals who know each other, for example, family members. The commentary to Standard 1.6 now has a list of factors that can help a therapist decide whether this is appropriate or not. These factors include whether the therapist can remain objective and maintain confidentiality, whether certain topics need to be avoided in therapy, and whether or not this is feasible, and related to small communities, the availability of other services and resources. Each situation will be different, so it's not possible to provide a definitive answer.
The next highlight we want to cover involves advertising and expanding one's areas of practice. Revised Standard 2.1 distinguishes between, on one hand, encountering a difficult client or issue within one's area of practice, and on the other hand, changing or expanding one's practice area. Regarding the latter, Standard 2.1.4 now says, registrants complete appropriate verifiable education and receive clinical supervision or consultation before changing or expanding their practice area. Several of the terms in that sentence are defined, so you may want to refer to those definitions. Psychotherapy is very diverse, so CRPO is not in a position to say exactly how much or what kind of education or supervision is necessary for a particular change in one's practice area. It would depend on various factors, such as how big the departure is from one's current practice area, how experienced the RP is overall, and how risky the new practice area is. Ultimately, a registrant should ask themselves what a panel of their peers in the profession and in the public would consider as reasonable. Revised Standard 6.2 runs parallel by talking about what practice areas a registrant can publicly advertise. It is similar, stating at 6.2.7, registrants advertise an area of practice only if they have verifiable training in that area of practice. The commentary below talks about therapist directory websites, cautioning registrants to think carefully before clicking on a drop-down menu or list of practice areas, because they will be declaring that they are competent in that area.
Standard 3.6 regarding the complaints process has been amended to include the expectation that as part of the consent process, registrants inform clients that the registrant is registered with CRPO and that CRPO is the organization that sets the rules for and considers complaints about registered psychotherapists. This is not a new requirement per se, as the previous standards noted in the Section 3 introduction that registrants must ensure that clients understand their right to make a complaint to the college regarding a registrant's professional conduct, and also where to take such a complaint. So while this isn't new, it is being brought into the standard for the first time. This was also recommended as part of a trauma-informed review about the investigation process that was commissioned by CRPO. This expectation is related to the requirement for registrants to use the regulated title, such as RP, although not all clients will know what RP means. Standard 3.6 is intended to be flexible. Registrants can decide how and where and when to inform the client. It could be on the forum or as part of the discussion, provided it takes place within the consent process. It doesn't provide exact wording that needs to be used. The standard is also not intended to invite complaints from clients about the registrant. Rather, it helps empower clients. A client might realize they have the right to file a complaint about a different regulated professional who acted in a questionable manner.
The next highlight covers the professionalism expected of registrants in their role as clinical supervisor. The standards have a lot of rules about how therapists act toward clients. Over the years, we have heard feedback that similar power dynamics and the potential for misuse can occur in a similar manner between supervisors and supervisees. We have also seen complaints and reports about supervisors involving, for example, a dual relationship with a supervisee, sexual harassment of a supervisee, or asking a supervisee to loan money to the supervisor. So we have made expectations explicit in Standard 4.1. The commentary now gives several examples like avoiding conflicting roles, sexual misconduct, undue influence and abuse, and making mandatory reports where needed. These expectations are not really new or surprising. Rather, they have been made explicit so supervisors and supervisees both know what their rights and obligations are.
To Standard 4.2, we've updated the guidance on the frequency of meeting with one supervisor. Previously, various stakeholders felt that the suggested ratio of 1 supervision hour for 4.5 or 10 direct client hours were unrealistic and too costly, especially for RPs who are just starting out. As you can see on screen, it now says that clinical supervisors and supervisees have a joint responsibility to determine the appropriate frequency of meetings, taking into consideration factors such as the level of experience, areas of competency, the nature of therapy, the size of the caseload, and other supports being accessed by the supervisee. Setting regular meetings in advance is an important practice for making clinical supervision a habit and ensuring issues are addressed promptly. For example, a relatively new practitioner, such as an RP qualifying registrant, should receive a recommended minimum of approximately 1 hour of clinical supervision per week, while a more experienced practitioner, such as an RP working towards independent practice, should receive a recommended minimum of approximately 1 hour every 2 weeks. Additionally, shorter meetings can be held as needed. Again, the exact frequency will depend on individual circumstances. The aim is to promote safe practice and professional development while being sufficiently flexible as to meet the needs of both the supervisor and the supervisee.
Over the years, CRPO has received many queries and complaints around RPs providing reports, particularly when those are later used by clients in their divorce and custody proceedings. Another area of concern involves motor vehicle accident reports or other insurance-related reports. In response, Standard 5.2.2 now says, when providing a report or certificate, which I note includes a letter, registrants indicate whether they are providing opinion, stating objective fact, or summarizing information provided by a client. For example, registrants may preface a statement with "the client said" to avoid portraying the content as an objective fact. If the registrant is expressing an opinion, they should state this and ensure they have a reasonable basis. For example, a registrant cannot assess a person they have never met, nor diagnose anyone.
Testimonials from clients, former clients, or other persons regarding a registrant's practice are not permitted in advertising. This was true even in the previous version of the standard. Testimonials are subjective and may be unreliable. They may also be misleading, as each client is unique and each situation is different. A technique that works well for one client may not work for another. A client's plan of therapy should be based on the individual's client need, not on the experiences of others. Testimonials may also lead to concerns that clients have been pressured into providing them, which is not in the best interest of the client or the therapist. In the updated version, we've taken a clearer stance on reviews and endorsements, which are types of testimonials. First of all, clients are not prevented from reviewing or endorsing registrants, for example, on third-party internet sites for rating professionals, provided registrants do not request them to do so, and provided registrants do not influence which reviews or endorsements are published. That means something like Google reviews are not in violation of the standard, provided the registrant does not pressure clients to post, delete, or change reviews. Similarly, registrants are expected not to advertise or promote third-party reviews or endorsements about them, as doing so could be misleading. For example, a therapist's 5-star average rating does not imply that the registrant is in the best position to treat a particular client, nor does a local award indicate fitness to practice with specific clients. Advertising these types of awards or commendations are similarly prohibited under the standard.
Moving on, next, most registrants are health information custodians. Some are not. If an RP is employed exclusively by a hospital, agency, or centrally run clinic, they may never have primary responsibility for maintaining health records, though certainly they have to act appropriately, do their charting on behalf of their employer with regard to records. Most RPs, however, do have custody of health records in one way or another, and they need to have a plan for what happens to their clients, their practice, and their health records if or when the registrant is unable to practice. Standard 6.4.3 now states, registrants who are health information custodians provide the college with up-to-date information about who would take custody of the records in their care in the event of the registrant's death or long-term inability to fulfill their obligations related to this position. The next numbered standard says registrants acting as health information custodians maintain records in a secure manner for the period set out in Standard 5.1, even after closure of their practice, unless the records are transferred to another health information custodian. From time to time, CRPO is contacted by clients trying to locate a copy of their records. These standards aim to ensure the information is secure and available if needed for the appropriate period of time.
Moving on to Standard 1.8, it has been expanded to include protections against abuse and undue influence for clients' representatives, family, partners, or other individuals with whom the client maintains a close personal relationship. The reason we have decided to expand these criteria is because a power differential still very much exists between these individuals and a therapist that could be exploited.
Clients have a right of access to a copy of their record, with limited exceptions, but this gets complicated if the client is a couple, family, or group. The commentary to Standard 5.1 now provides guidance. It says, registrants should explain to joint clients how records are kept and how they may access those records. Clients may access the entire record if all participants consent or submit a joint request. For example, both members of a couple request access to the couple therapy record. If only one participant requests access to a joint record and the others have not consented, they are only entitled to the information about themselves and any communal information, for example, general themes, that is not attributable specifically to another participant. Thinking about this in advance can help sort out what would happen if in the future a registrant receives an individual request for a joint record.
In terms of next steps for the standards, CRPO will soon be uploading the fully copy-edited version of the standards. There will be no substantive changes from the version that has already been circulated, but there will be some minor edits for clarity and formatting for consistency. We will also be posting a French translation. From there, we'll be revising peer circle and case-based assessment, or CBA, cases to ensure conformity with the new standards. Any changes are likely to be extremely minor, as the CBA is based on foundational expectations that have not changed with the standards review. For information on how to prepare for the CBA, you can visit CRPO's website and navigate to the QA program section. A quick note as well that the registration exam questions are based on CRPO's entry to practice competencies, which have not been changed. As you may have already noticed, the communique has been featuring short articles on changes for the last couple months, and those will continue for further awareness of the standards. We encourage you to take a look so that you remain in the loop with the standard updates. We are also planning a survey in the coming months for feedback on the standards rollout, which will hopefully give us some learnings for the next time we undertake a full standard review, which is tentatively scheduled for 2028.
That was the main part of our presentation. We're going to get to questions in a moment. Before that, we want to thank all of you very much for attending and listening. Of course, these were only highlights, so please look through the full document itself on our website, which goes into much more detail than we could today. For those who couldn't attend today or missed part of the presentation, a recording of this presentation will be posted and linked from our website, as well as slides and questions and answers. At this point, Pamela and I will answer some of the questions we received in the survey containing the RSVP for this event. We might not have time or be able to answer all questions, so please feel free to be in touch. Since this presentation was about practice standards, the most relevant email to use may be that of our practice advisory service, practice@crpo.ca. For more general inquiries about college operations or registration, you can email info@crpo.ca. So our most common topic where we received numerous questions was around children and consent. Nothing in the standards has changed in terms of responsibilities registrants face when working with minors in regard to consent and confidentiality. Just as it was in the past, the first step is to determine if a minor is capable of consenting to therapy or to the release of their information. There is no specific age cutoff in Ontario law. If the child understands the decision and appreciates the consequences, you need their consent. If the child is unable to understand and appreciate, you need consent from their substitute decision maker, which is usually, though not always, the parents who have custody. It can get complicated where there are court orders in place, the parents have different custody and access rights, or there are ongoing legal proceedings and disagreements regarding divorce and custody and healthcare decisions. In contentious cases, it is advised to seek legal advice and clinical consultation or supervision. We have some information about this general topic on our Practice Matters webpage, and we'll consider developing additional guidance.
Another question we received is why some information is contained in the standards while other information is in the jurisprudence manual and some in Practice Matters article. They wonder if the information can be contained all in one place or links provided between the documents. These are very good points, and we will consider how best to arrange and link the information. By way of some background, learning jurisprudence is a registration requirement and reflects three primary areas. First, what it means to be a regulated professional. Second, the professional practice standards. And third, are laws relevant to practicing as an RP. The jurisprudence manual is aligned with and reflects the standards, which are the expectations professionals are expected to meet. Practice Matters articles are intended to assist professionals with commonly asked questions, the answers to which are based on our standards. All three fit together to provide support to RPs in different ways.
Another question we received asks, does every fee have to be laid out for the client before services? How strict is this? For example, would you always want to tell the client right away what it would cost to release their record to them? They say, I'm wondering from the angle of planting the idea in a client's mind when it might be decided later that this is not really a good option, and they worry that conflict or damaged rapport from saying no could have been avoided. So registrants don't need to explicitly talk about every fee with every client. Newly updated standard 6.1.1 expects registrants to establish a fee schedule and make it available. They must confirm that clients are aware of their fees in general. Registrants only need to proactively inform clients of a particular fee before they provide that service. So to give an obvious example, it would be inappropriate to have a therapy session and then afterwards say, by the way, I forgot to mention I increased my rate by $50 since last time. Also, Standard 6.1.1 does not prevent registrants from offering a sliding scale.
We also received questions about the duty to warn, intimate partner violence, domestic violence, and children in need of protection. In general, we would refer you to Standard 1.3 in the Jurisprudence Manual, which covers these topics.
We received a few questions about supervision. We've covered a couple of supervision-related issues today. We're also currently working on a separate online learning module about supervision, as well as guidelines on what to look for in a course on how to provide supervision, both expected next year. We'll say more about these when they're ready. In the meantime, there is lots of information available in Section 4 of the standards, in the Jurisprudence Manual, and on our website.
Another question asks, can a registrant use the title doctor in an academic setting? For example, teaching as a professor, since there are no clients present and the registrants are not offering or providing healthcare. Yes, they can use the doctor title in that situation, but not when offering or providing healthcare in Ontario. Obviously, they should have a legitimate doctorate degree before using the doctor title, even in an academic setting.
Another question asks, what is the time frame for doing business with a former client? There is no specific cutoff or time frame, but there is a list of factors to consider listed in Standard 1.7.
Another registrant asked whether we could go over the parameters of emailing. Ordinary email does have security risks, so clients should be made aware of those risks, and it is recommended to avoid sensitive topics and stick to administrative matters like scheduling over email.
One person asked for an update on bartering, which is the exchange of services like therapy for other goods and services other than money. The updated standard 6.1 takes a stronger stance, discouraging bartering due to the risks it carries. However, it is not outright prohibited due to the very limited circumstances in which it may be justified.
Another question came in noting that many colleagues are using psychedelics, wondering if that is against the standard. The Jurisprudence Manual has some guidance on this, and we are currently working on developing additional guidance, so please check back with us in the next few months. In such circumstances, it's important to remember the standards. For example, 2.1 requires that registrants complete appropriate verifiable education and receive clinical supervision or consultation before expanding or changing one's practice area, and requires registrants to only provide services that are within their knowledge, skill, and judgment to provide.
And another question states, can you expand on our mandatory reporting obligations for cases where we have concerns about the licensure status or practices of other RPs or unregulated practitioners? We have a lot of information in Standard 1.3, Jurisprudence, and on our website on mandatory reporting, for example, about unsafe practices by another RP or sexual abuse of a client by a regulated healthcare professional. There are several of these mandatory reporting obligations. There is no mandatory reporting obligation to say that someone is holding themselves out as a psychotherapist who is not regulated. However, we do accept discretionary or voluntary reports about these unauthorized practitioners. We also have a webpage on this topic.